Welcome everybody to Law&Crime Daily. I'm Jesse Weber. The much talked about burn after reading letter sent from Roberta Laundrie to her son Brian has been released after a judge determined it could be included in a civil lawsuit between the Laundrie family and the family of the young woman that Brian killed. Now, this is the letter that family members of Gabby Petito wanted to see. And while it contains multiple intriguing sentences that are definitely raising some eyebrows, there's no indication on it as to when it exactly was written. Well, right now we're going to break down some of the biggest revelations in that letter. So Gabby Petito's parents are suing the Laundries and their family attorney for intentional infliction of emotional distress. They claim that the trio hid the fact that Petito was dead and instead released misleading statements to the public. Gabby Petito and Brian Laundrie set off on a cross-country road trip in July of 2021. 2 months later, Laundrie returned home from the trip alone, and Petito's body was found on the outskirts of a Wyoming national park. The next month, Laundrie's remains were found in a park near his Florida home with a journal confessing to the murder. In a hearing on Wednesday, an attorney for Joe Petito and Nicole Schmidt argued in favor of releasing the burn after reading letter. The judge granted the family access. The letter Roberta Laundrie wrote to her son Brian was in an envelope with burn after reading written on it. The judge said that the letter could serve as evidence to prove that the Laundries knew Petito was dead when the letter was written, although the Laundries claim it was written well before the road trip. So let's break down some of the biggest discoveries in this short letter. First up, this line, "If you're in jail, I will bake a cake with a file in it." Now, of course, this is pretty damning since Brian Laundrie could have been arrested for murder had he not died by suicide. There's another line, "If you need to dispose of a body, I will show up with a shovel and garbage bags." Gabby Petito's body was found a few weeks after she died from strangulation, according to a Wyoming coroner. And then there's this third line from the letter, which corroborates Roberta Laundrie's statement that this letter was a way for her just to try to connect with her son as they went through a very tough time in the relationship. She wrote, quote, "No matter what we do or where we go or what we say, we will always love each other." Joining me right now, legal analyst Brian Buckmeyer, Terry Austin. You guys have slightly different views on this letter, so let's dive in. Terry, you agreed that the letter should be admitted into evidence. Why do you think it's relevant?
It's completely relevant. It should be admitted because whether this is literal or figurative or whether this is code, this letter should be admitted, and a judge made the right decision. And I think it's up to the jury to determine what the date of that was based on any forensic evidence. It's up to the jury to decide whether she was being literal or figurative or somehow using a code. And so I think that the judge has to determine, is this prejudicial or is it probative? He made the right decision. It is definitely probative. You have to wonder what was in the minds of the parents when they were writing this. And actually, I do think that the Petitos have a very good argument that they knew where that body was, they knew that she was dead, and that they were hiding it in some way, shape, or form from the public, and they were trying to help their son do the same thing.
Well, Brian, it certainly seems like damning evidence against the Laundries, but how would you argue otherwise if you were their attorney?
Two arguments here, Jesse. One, it's only relevant, if to Terry's point, if the letter happened either before or when the parents knew that Gabby Petito was deceased. They're saying that that didn't happen. The timing makes it irrelevant. The other side is saying, well, we think it happened at this time. That's not a legal argument. That doesn't combat that. Also, all the points that you read out, yeah, those are damning lines. But she also says, if you fly to the moon, I'll watch the skies for your re-entry. And if you hate my guts, I'll get new guts. That's definitely a hyperbole. So what are we going to do? Pick out some sentences that are true and then say that other sentences are hyperbole? Or just say in its entirety, this letter clearly appears to be a hyperbole and not an actual true statement of what she would do?
If we only knew when that letter was written, it would clear up a lot of this confusion. There is another issue at that hearing I want to talk to you about, and that was whether former Laundrie family attorney Stephen Bertolino would be added to the civil suit. Attorneys argued motions to dismiss the civil case as well as motions to drop Bertolino from it. The Petito side contends that Bertolino made statements about wanting Gabby to be found when he actually already knew she was dead. They said that this was cruel. The judge said that she'll rule on the motions to dismiss in a written order. Over now to another story that we're following closely. The man convicted of shooting at a police canine while trying to get away from officers following a killing spree won't face sentencing just yet. K-9 Riggs and some of his other four-legged colleagues stood outside the courthouse waiting for Alan Brown's sentencing hearing. In October of 2021, Wisconsin officers were notified that Brown was in a stolen vehicle headed in their direction. He's suspected of 2 homicides out in Chicago. Kenosha police caught up with him and he tried to run when Deputy Terry Tift unleashed K-9 Riggs. Brown shot him in the head. Now, fortunately, K-9 Riggs survived with only a bruised skull and actually returned to the force weeks later. Brown was found guilty of multiple charges and was supposed to be sentenced on Thursday, but he refused to come to the courtroom. That's right. After a long delay, the judge decided that Brown would appear via Zoom from his cell. But when the hearing started, Brown's lawyer informed the court that Brown wasn't taking his medication and that his competency had been called into question. The judge then stopped the hearing and said that they will have to be dealt with before sentencing can continue. And welcome back to Law&Crime Daily, everybody. We have an update in last month's deadly DUI crash in South Carolina, killing a bride on the night of her wedding. The victim's husband, who was injured in the crash, is now suing the driver and the places that sold her alcohol. Samantha Miller and Eric Hutchinson were leaving their wedding reception in a golf cart on South Carolina's Folly Beach. And that is when police say Jamie Lee Komorowski hit the newlyweds with her car, killing Miller. Hutchinson was injured along with other passengers in the golf cart. Investigators say Komorowski, a New Jersey resident, was going 40 miles over the speed limit in a rental car and had a blood alcohol level 3 times the legal limit to drive. Komorowski was arrested for reckless homicide and felony DUI. Hutchinson was able to leave the hospital, but with 2 broken legs as well as broken face bones and other injuries. Now he's filing wrongful death lawsuits against Komorowski and a number of local bars and restaurants. The lawsuit states, quote, despite being noticeably and visibly intoxicated at each of these establishments, Komorowski continued to be served, provided, and or allowed to consume additional alcohol at each of them. The groom is asking for funeral and burial expenses in addition to actual and punitive damages. A GoFundMe page has raised more than $730,000 for the victims in this crash. Well, this scenario might sound familiar to our viewers, as another wrongful death lawsuit in South Carolina has made headlines in the Alec Murdaugh saga. The family of 19-year-old Mallory Beach is taking the disgraced attorney and a convenience store chain to civil court in August. Murdaugh is currently serving 2 life sentences for killing his wife Maggie and son Paul. 2 years before Paul was killed, he was allegedly driving drunk when he crashed a boat into a bridge at high speed, ejecting all 5 passengers. Mallory Beach died and several other passengers were injured. The Beach family claims that Murdaugh, along with Parker's Kitchen, are liable for their daughter's death after Paul used his older brother Buster's ID to buy alcohol. Let's break it down. So, Brian, can all of the bars that Komorowski went to be held liable for what she did after she left?
I think it's going to be extremely difficult to be successful in that type of argument, and it's for this reason. I think that the last bar is probably the most culpable of the other bars, because if there is a duty at all for the bartenders or people serving alcohol, it's to the person who observes Komorowski leaving intoxicated. All the other bars can basically do the whole Spider-Man meme, pointing at each other. So let's say, for argument's sake, the 3 bars, Heather's, Savannah, and Kathy's. If they went to the bars in that order, Heather would point to Savannah's would point to Kathy, and Kathy's bar would probably be the liable one. And I think that's likely going to be the argument, that one bar may be more liable than the others.
Those are all our producers that you named. I'm not sure they're going to be happy that you put them as
well,
bars
I put Kathy's
in
that order for a reason.
Yeah, I get it. But Terry, so during a call from jail with her father, Komorowski says that she hopes the judge is going to go easy on her. You think that's going to happen?
I don't think that's going to happen. First of all, I do agree with Brian. I think that the bars should be responsible, particularly that last bar, because that person who served her should have observed what condition he was in. But as far as her individual liability is concerned, I definitely think even if she shows remorse, even if she takes responsibility, even if she talks to the judge should probably give her the maximum. The DUI, she could get up to 15 years, and for the reckless homicide, she should get 10 years. Maybe he'll make it consecutive. I think 25 years is probably too much, but I do think she needs to learn her lesson. She spoke to her father, and he told her to suck it up, and essentially she is going to have to do some sort of time, I think, for the public to think that there's been some kind of justice here. She killed one person, seriously injured another person. She should pay some time.
And basically ruined, his life. It's really just a heartbreaking story. And when we come back, another sad story. A woman is left paralyzed in New York City after being pushed into the side of a moving subway car. Up next, we break down why this one incident could be part of an even bigger problem. And we're finishing today's show with another incident in the New York City subway system. A homeless man was charged with attempted murder this week for shoving a woman into the side of a subway car, leaving her paralyzed. The victim, 35-year-old Amina Yilmaz, immigrated to the United States from Turkey in 2017. Her art has been published in magazines and company campaigns for brands like Airbnb and Puma. At around 6 Sunday morning, Yilmaz got off of a subway car at the 63rd Street and Lexington Avenue station headed to work. Authorities say the suspect, 39-year-old Kamal Simrad, pushed her head into the side of the moving subway car from behind. According to court documents, Yilmaz suffered severe injuries, including a cervical spine fracture that left her paralyzed from the neck down. She's hospitalized in critical condition. Simrad was arrested and charged with second-degree attempted murder on Tuesday after police identified him on surveillance video. His next hearing is scheduled for Friday. The victim's husband released a statement following the attack, and it reads in part, quote, "She is a person who has strength, who is resolve, who is determined, and all of that was taken from her. It is crucial for the mayor to recognize that prioritizing the safety and security of the city's residents is vital for their well-being and prosperity. This incident occurred around 6 a.m. on her way to work in the heart of Manhattan. This underscores the pressing need for improvement with the MTA. We must ensure the ability to safeguard individuals, including loved ones like my wife." Now, there have been a string of incidents in this past year that highlight safety concerns on New York City subway, especially when it comes to the city's homeless population. So in January of last year, 40-year-old Asian American Michelle Go was killed at the Times Square 42nd Street station. She was pushed from behind onto the path of an oncoming subway train by 61-year-old Marshall Simon. This is a homeless man with a history of mental illness. Simon turned himself into police shortly after, and he was charged with second-degree murder. He was eventually deemed unfit to stand trial and was permanently housed in a psychiatric facility. And earlier this month, Marine veteran Daniel Penny was charged with second-degree manslaughter after choking homeless man Jordan Neely to death on a subway car at the Broadway Lafayette Street station. Penny plans to testify before a grand jury next month and say that he acted in self-defense against the homeless man, who also had a history of mental illness. Witnesses told police that Neely began shouting on the subway car about being hungry and not caring if he returned to jail or even died. But those witnesses say he was not acting violently when Penny suddenly intervened. Let's talk about this. Terry, could New York City be held liable for injuries that were caused by Simrad?
Well, I think you can certainly bring a civil complaint. I think it would be very difficult to bring a criminal charge against the city or the authorities or the police, because the Supreme Court has held that they only have a duty for individuals who are in their custody, and obviously they cannot prevent murders from happening. But from a civil perspective, I do think that there is a claim here. We know about all of these incidents because you just named some of them, Jesse. So the city is on notice that this is happening. Perhaps they should have had more police on the site. Perhaps they should have done something as far as the MTA is concerned, built the subway in a different way. I do think that they could bring some claim against the city for negligence. And here, someone was severely injured. So there is this duty, and the duty was breached, and there was this harm. And so whether or not they prevail, I think you could bring that claim, you could make some arguments, and ultimately there might be a settlement as far as the family is concerned.
Brian, can we talk about the charges for a second? Attempted second-degree murder. Why not attempted second-degree manslaughter? How is what Penny did any different than what Simrad did?
So arguments can be made that Penny could be charged with second-degree murder, but he isn't. And I think the major reason for that is one sentence: depraved indifference to life. That's the major difference between the second-degree murder and second-degree manslaughter. Could you say that Penny strangling Neely past the point of him passing out is depraved indifference to that person's life? Absolutely. But from a legal standpoint, I think it's a lower level of depraved indifference than, I don't know, pushing someone onto the railroads of a train station in the way that this person had. And so, could both be charged with murder? Yes, but I think they are properly charged with what they're facing based on the level of culpability and the mindset that they have towards someone else's life.
No, I agree with you, and it's just horrible that we have these two real-life examples and we're weighing it on a legal sense, because we shouldn't have these examples. That's the problem. Brian, Terry, thank you. Everyone out there, thanks for joining us here on Law&Crime Daily. We're going to see you next time as we discuss justice in America.